subsequently we found out that it was the ICPC that procured the DSS to abduct me and then hand over to them. And this is a modus operandi of the ICPC that increasingly has become a personal tool of Nuhu Ribadu. Nuhu made the call and made the order that I must be in custody yesterday.
How do you know he made the call?
He made the call because we listened to their calls. The government thinks that they're the only ones that listen to calls, but we also have our ways. He made the call, he gave the order. And
so you tapped his phone calls, did you?
Someone tapped his phone and told me.
Because that technically is illegal.
I know, but the government does it all the time. They listen to our calls all the time without a court order. But someone tapped his phone and told us that he gave the order. So, but the EFCC, I think, has shown itself to be more professional in this particular instance.
That's the former governor of Kaduna State, Nasir El-Rufai, speaking on this program on Friday. Well, to interrogate the facts, the law, and the politics driving this unfolding drama, I'm joined now on the line from Lagos by Babatunde Ogala, OFR, Senior Advocate of Nigeria and former National Legal Advisor to the ruling APC party. Mr. Ogala, thank you very much indeed for joining us. We appreciate the time. I know you've had a busy day, so we're grateful that you could find the time to talk to us. Now, based purely on the statement which Malam El-Rufai made, saying, quote, "we listen to their calls," unquote, does that automatically meet the legal threshold for unlawful interception under Nigerian law? I mean, is a televised remarks sufficient grounds for criminal charges, or must there first be forensic proof of an actual interception?
Well, thank you very much, Charles. It's my pleasure to be here to give my quota of understanding. First, let me say, in criminal prosecution, the onus is on the prosecution to prove the case beyond reasonable doubt. As it were today, what we've just heard is that charges have been filed, 3 count charges under the Cybercrime Act and the Nigerian Communications Act have been preferred against El-Rufai. I have not seen the proof of evidence to be able to determine what is contained therein. But it would be safe to presume that the prosecution team would also have done their homework before bringing these charges. As to whether tapping or invading or listening in, albeit through any other means, albeit other than that provided by the law. In my humble opinion, I think beyond the Cybercrime Act, it may even offend sections of the Data Protection Act. And let's not just imagine that it's because it is the National Security Advisor. Even tapping my own line, or Charles, indeed, your own line, offends the law. And it is worse when it is that of the National Security Advisor. And you are saying, and we are not talking about Nuhu Ribadu's line. We ought to distinguish the official line. I don't think anybody in any responsible country, and where there is a responsible government, will come up and say he has tapped into the security architecture of that country. And then the government will look the other way. But I will say, if it is Nuhu Ribadu's line that has been hacked, it certainly, there will be an offense that may be established therefrom. But when you go on national television, and I think here I want to appeal to us to take away politics from criminality. I can't imagine for the minute in that country where they say freedom is almost absolute, anybody can say anything. I don't think any American will wake up tomorrow and say we have tapped into the official line of the Pentagon and expect that the country will look away. He will certainly be invited to come and make some explanations. And whether investigations have been done or not, there is a presumption that it may have been done. And this is an admission on national TV. It's like me walking into Tejo Show Market or Yaba bus stop, and I say there, I have just killed somebody. And then you imagine that because I might have freedom of speech, the police should first go and establish if I committed the offense before arresting me. Where I have come to the bus stop to admit to a heinous crime. I mean, if this is allowed to go, someday, sometime, somebody else will say on national television, I'm going to shoot the president tomorrow. And you'll say it is political talk. If indeed it was political talk that El-Rufai was making, I think that would appear to be taking the freedom too far. And let's also not forget, because more often than not, when we talk about personal security and all of that, do we realize that even the Supreme Court have even given the government the powers of detention of persons, that is to breach your constitutional rights to freedom of movement, if in the interest of overriding national security. The case of Asari de Kubo is very clear, where my good brother Festus Keyamo SAN argued up to the Supreme Court. And the principle was established there. So for me, like I said, I will make only informed commentaries when I am seized of the full facts. And the full facts means seeing just before the charges, the 3-count charge that is in the public space.
Okay.
But I think, in my humble opinion, as long as the charges are supported by provisions of the law, the DSS, or indeed the Federal Republic of Nigeria, in whose name the charge has been brought, is doing the right thing by profiling this charge against Malamet Nasril.
Okay, well, thank you for setting your stall out there from a legal point of view. That's quite important for us to be clear on that. But as you know, I mean, the DSS filed charges at the Federal High Court in Abuja. From a procedural standpoint, is that unusually swift? I mean, should a matter with national security implications first undergo internal intelligence review before becoming public litigation? Did you hear me there? I don't know if your line is frozen.
I want you to take that again.
Okay, sorry, I think your line froze there. And just as briefly as you can with your answers, because we need to get to quite a lot of things here. I said, the DSS, as you know, filed charges today at the Federal High Court. From a procedural standpoint, is that unusually swift? Should a matter with national security implications first undergo internal intelligence review before becoming public litigation?
I don't know what you mean by unnecessarily swift. The alternative, if they don't want to be swift, is to get a court order to force detain him. Perhaps which the law permits for maybe a period of 14 days before bringing the charges. There's nothing swift about investigations. If you have the facility to do your investigations within 1 day, so be it. I mean, the totality of the evidence might just be right there in front of you. Right there in front of you. you will arise. This statement was made on your station only on Friday. I don't know what may have happened. The directorate of the DSS may have gotten all the information they want from you. They had the whole of Saturday. For the 8 hours, they had the whole of yesterday. They may have gotten everything. It's about the sensitivity and the nature of the allegation that determines. There's no time limit to which the law does not prescribe that you must give a certain time frame before filing your charges. So there's nothing like being swift. And having done so, it's not the end of it. It could be amended and what have you. And it could also be a way to avoid a situation where they don't want to keep him in detention unnecessarily, which they could have done, take him in, go this morning, obtain an ex parte application in court to detain him for 30 days. I think we should even commend them for being swift rather than saying it's unnecessary. The DSS should be commended for bringing charges as swiftly as they did, rather than just keeping the man in detention for pending investigations.
Right. Well, to be clear, I didn't say unnecessary. I said unusually swift. There's a clear sort of difference there. But let me ask you this.
Was my word. The unnecessary was my word, not yours.
Yeah, okay. Let me ask you this. Is there any risk that public commentary by public officials could prejudice judicial proceedings? For instance, the president's spokesman, Bayo Onanuga, issued a tweet about this on X. Does his public characterization of El-Rufai's remark as a confession risk undermining the presumption of innocence?
Whatever the Bayo Onanuga, Babatunde, Ogala, or Charles would have said have no relationship with the proceedings in courts. The court is going to be guided by the evidence before it and not by what people are saying on the streets.
Right. Given the political fallout, I know you made a distinction between the politics of all this and the criminality or legality of it all, but you were a former legal advisor, national legal advisor to the APC, so I have to ask you this question. Given the fallout, the political fallout between El-Rufai and the current administration, how does the government avoid the perception of selective prosecution? I mean, would the same urgency apply if the individual involved were a close ally of the presidency?
Well, I'm not in a position to answer that, only because if I go by your question, would it be the same if the persons involved were close allies of the presidency or not? It's only the presidency that will tell you if they will use selective judgment in determining the way forward. But I think this should not even arise, and such a question ought not to even arise at all. We should focus on the issue. Whether you are an ally of the president or not an ally of the president, what we should focus on is the act. Does it constitute an offense? Has it done anything that demands scrutiny of the security agencies? Have there been anything that has been put before the court for the court to even look at? This is an issue of national security, and I'm sure for a responsible government and any responsible government, which I know this government is, even if you are the closest friend of the president, if you make public statements that border on national security, I'm sure the government will certainly take a look at what you have said. And you will not be an ally or a close friend of the president and say on national television and say, I tapped the president's phone, and expect the president or the government not to take action because you're a close ally. So this has nothing to do with
Okay, let me come in here.
We we should look at the merit or otherwise of the utterances.
Right, okay. Well, let me come in here. If a former governor truly had independent wiretapping capability, although he didn't say he did, what he actually said was that someone else listened in and informed him of what was said. But if he did have independent wiretapping capability, wouldn't that represent a systemic failure of Nigeria's security infrastructure?
You would call it a systemic failure. That would be uncharitable. That would be incorrect. Even the American, where the security is said to begin and end, they constantly hack into their systems. Even in China, they hack. All over the world, they hack. Technology, security architecture is technology driven. And those who want to hack, those who create viruses in computers are always ahead too. And that is why, so it has nothing to do with failure. It just simply means there is elements of sabotage, because in whatever security architecture you claim to have, whatever network you have put in place are still managed by human beings who could also sabotage the system. So it has nothing to do. It's just an element of sabotage. It's an element of some people maybe are getting to some superior technology or finding loopholes somewhere. And that is why it is continuously improving. I remember the last round of elections. With every technology INEC puts in place, it did report that there were about 12 million attempts to hack into its system. We only need one to succeed out of 12 million. 1 out of 12 million, if they were able to protect it, or the remainder other than the one that hacked, that does not mean failure. So it would be uncharitable to suggest that somebody had come on there to say I hacked into the National Security Advisors or indeed any citizen's phone. I mean, if we didn't realize that there are possibilities of these hacks and what have you, then there will be no need to have made the cybercrime protection law. There will be no need for a communication law. There will be no need for creation of these offenses, because we know the possibilities are there. And it is like that globally. They know people will always hack. They know a criminal will always be a criminal. They know mischief makers will always be mischief makers. And they know that those who want to compromise the system, compromise the state, will always continuously make attempts. They are not sleeping. It was one musician that once sang that, I want a Mishashe, I don't want Shashe. His own people were working overnight, hacking and trying to defraud, while all the rest of us were sleeping. So as you are going to sleep after this program today, mischief makers are also attempting to hack even into Arise system. Even the interview we have today, don't be surprised that somebody hacks into it. It superimposes your photograph or your video talking to me, or put your voice to somebody else, and they can even distort everything we are discussing now and post online. So it's a continuous process. It does not mean Arise would have failed because somebody somewhere who has a mischievous, fatal mind has superimposed Charles Anyagolu
Right.
against Ibiki Ogala or against any other person.
Well,
it is absolutely not a failure.
It's interesting that you say that, because they have actually done that. I mean, I've had my voice and my face.
That's why when I started.
But let me just move on very quickly, because we've really got to move fast. To be able to secure a conviction, what must prosecutors prove beyond reasonable doubt? Would the alleged victim, the Office of the National Security Advisor, need to demonstrate measurable harm?
Of course, absolutely. The prosecution must prove beyond reasonable doubt that this offense was committed. Perhaps the job is half done, because there is a confession. It was a confession unsolicited on national television. So her rights too, I presume, may even be one of the witnesses in this case. If he spoke with the Charles Anyagolu, I think you should start preparing yourself for the witness box. Her rights too, because that is the platform in which he made these comments, in which he made this statement. I don't know if it was a liberious statement. I can tell you for free, and the client approaches me, and I consider it defamatory, our rights to will be defending. Yes, that is if it was like a defamatory statement, because you were the publishers. So you too should be. So there is a presumption that the Department of State Security has done its work, albeit, like to use your own words, very swiftly, and they could still do more. As new evidence arises, they can still amend, they can provide additional proof of evidence. So filing the charge is not the end of it. The man's plea will be taken. He may get there the day he is arraigned, because it's only the charge that has been filed, he has not been arraigned. He may get there the day he is arraigned and say, oh, I am guilty. And that will be the end of it. He may also plead not guilty. And the prosecution or the DSS, as it were, will now be called upon to come and state the case, provide the evidence, they provide the evidence before the court. He will also be called upon to state his defense, to say, oh, had I did not say it, he could well also come to court and say, oh, I didn't say it on arise, it was AI, it wasn't me. And if he successfully proves that, that may be the end of it. So it's not automatic that the conviction will be gotten, or that the man will be convicted or not convicted. But one thing I would say, it would have been irresponsible of the government not to take any action. An action will have to be taken, and is to act as a deterrent.
Just to be clear,
I only pray and I hope. No, sorry, I say I only pray and hope that the rule of law will be allowed to take its full course, and not politics.
Well, just to be absolutely clear, again, he didn't actually say that he hacked into anybody's phone, nor did he say precisely that someone else hacked into a phone. He said someone listened into the conversation and then told him about it. But let me ask you this, because we're almost out of time. In summary, as a senior lawyer that you are, give us your bare bones assessment with the politics stripped away based on the little information that's available to you at the moment. From what you know publicly today, does this look like a legally sustainable prosecution or a legally vulnerable one?
I won't be in a position. Well, prosecution, yes, there's something to prosecute. Whether it will lead to a conviction or not, I'm not in a position to determine based on what I know. But from what I've seen, charges have been brought under the Cybercrime Prohibition Act and the Nigerian Communications Act. Do those laws exist? Yes. The offenses that are stated in the law, do they exist? In my opinion, yes. Does what the man is presumed to have said, would it constitute offenses under this law? That is for the court to determine and for his defense team to put up. But as to whether there are charges that are properly before the court, yes, there are charges before the court, because the Section 12(1) and Section 27 of the Cybercrimes Act and the Communications Act, under which he has been charged, are subsisting and valid provisions of our laws.
Well, on that note, I want to thank you very much indeed for helping us to interrogate the limited facts that we know at the moment, as well as the law surrounding all of this. Babatunde Ogala, OFR, is a senior advocate of Nigeria, former national legal advisor to the ruling APC party, and he was talking to me on the line there from Lagos. Thank you very much indeed.